Hello, hello, check, sound check, 1 2 3, check 1 2 3.
हेलो हेलो अनम्यूट कर
एक ही तो मैं उसमें भी
Announcements. My lords, may I seek your lordship's indulgence, my lords. We have already sent an email to the registrar. A impugned order has brought the entire copywriting licensing to a standstill, saying that until and unless you're registered with the society, you can't license. So all industries cutting across software, audio are affected. We are only praying for Monday, my lords. Because the entire business in an interim order has been come brought to a standstill.
When the letter comes up,
It's been sent, my lords. It's
just a call, there is no reason for you to even mention.
very well, very well,
Haven't you seen the calls list?
very well.
How, listing is taking place.
Yes, my lord,
almost
we are very grateful. Just the
within
anxiety
2 days
because
of-
the whole business
No,
has come
no,
to a standstill.
don't. If you had any issue, please go ahead.
We'll follow it, my lord. It's only a request that we are making.
My lords, I have a special circumstance. This is a habeas corpus. The father took the child, mother writes a message saying I can't accompany, files a habeas corpus. The High Court requires me to produce the child today without even giving me an opportunity to explain the circumstances. My lords, we've sent the email. I'm saying today, my
No,
lord, I'm
not
not, I
today.
cannot.
Monday, please. Monday. No, Monday.
My lords, there'll be NBW otherwise issued.
No, please. Please, surrender. Give
My
the
lord,
child. Doesn't make a difference. The child can come back.
My lords, then keep it on Monday.
No, Monday. Monday.
I beg your pardon, my lord?
Monday.
Monday. Very well, my lords. I take that.
Let's,
Grateful, my lords.
let's,
7. It was listed yesterday as 54 for tea tattoo. It's been listed again, it's still not effect and the senior has to be engaged. I'm just requesting that the matter will be listed next week and we.
No, please. We'll take it up in his turn. Take it up in his turn, we'll see. No, please. We'll take it up in his turn and we'll see.
there is one matter among the work batch of matters where the petition has been numbered and
Sorry.
before
Come up.
14th.
Sorry, it'll come up on the due
It
date.
was numbered before 14th.
Sorry.
my lords.
Sorry.
My
Not
lords,
not like that, please. And we may today, not like this.
Lord, before your lordship has asked me to join the investigation, Lord, I had on the previous day. Before that, I had Lord joined. Somehow, probably the affidavit of the respondent, Lord, must have come to the office here. It was attested on the 5th, but I had
Yes,
attended the
no,
hearing.
but the allegations against you are quite serious. You can't, the allegations are not something which is, these are, when things like this are done, there's a complete forgery which has taken place.
Lord, I had nothing to do with that. I was not even physically
Tanta,
present there.
Mr. Tanta, this
Yes.
is, they have carried out the investigation and I am a little surprised at Allahabad High Court granting bail. One, is it correct that the other two are advocates?
No, Lord.
Other two are, I could make out one of them is an
No,
advocate.
he's the
Advocate's
assistant clerk
clerk.
of the,
Clerk,
one of
my
those
lords.
advocates.
They are advocates?
Clerk.
Clerk of an advocate.
That's right, my
Sorry,
lord.
Mr. Thamta.
Lord,
Can't help you.
Lord, I have joined the investigation.
Maybe Mr. Thamta.
And they say.
No, Mr.
I am
Thamta.
cooperating.
Mr. Thamta.
Yes, ma'am.
Somebody forges the sale deeds, the photographs, takes over the identity of another person, and then he tries to get the property transferred, land transferred, and you say we should grant
Neither
explanatory bail?
beneficiary nor anything. I didn't
Sorry.
even visit the office of that
Sorry, please.
Yeda.
Sorry, we are not inclined to interfere with the impugned judgment and hence especially petitioners.
Please.
Extremely grateful, my lords.
Please, Your Lordship.
Yes,
And the original respond number.
no, you can't file an application like this. You will have to challenge the order. No.
Lordship may kindly see because they
Yes, sir.
filed this forged document
No,
for your Lordship.
please. Now, we did not go into the question of merits of the document.
Because with the archives department admitted
Please
its fact, even
go-
the committee has
please
been
go
constituted.
before either the National Green Tribunal, if the matter is
Because
pending there,
Even,
or if the matter
even in
is not.
TN Godavarman, the same issue come up.
Sorry,
In
please.
regard to 1944 Gazette.
Joe, please, look, we did not pronounce on the document. We merely.
Yes, Lord, I will come to that because on that document it has been pronounced with
Sorry,
great
not
respect
mistaken.
because they have come with the case that in view of the 1935
There was-
there is a deforestation.
Sorry, please.
So I will come
that-
to the relevant paragraph of Lordship's order.
We have seen that order, please.
Revenue Secretary's order. Lordship.
1 minute,
great
please.
respect.
No, please. We did not pronounce on the document. We said two things.
Yes, madam.
One, they have relied upon this document. They did not say whether the document is authentic or not authentic. Correct? Two, we said the order has been passed without hearing them. So the matter is remanded. Now, if you are of the opinion that the document which they say of deforestation,
Not of
please,
opinion.
now wait.
Yes, ma'am. Yes. Yes.
We also know that you are relying upon certain papers you have got. It's not that we don't know that.
Out of 10 volumes, 9 volumes are intact with the archive.
We are aware of that, what you have stated in your application. We have read your application.
Yes, my lord.
We are aware of that.
Yes, my lord.
But the remedy for you is either the National Green Tribunal, one. Two is if they have remanded the matter to the revenue authorities, and the revenue authorities have passed an order, file a writ petition or whatever you want to do.
Because in a similar
Right out.
situation, court order for a high-level committee and to be constituted
Right
and
out.
call the report, my lord. In
We
TL
are not
Godavarman.
inclined to entertain the present application in view of the order, in view of the limited order passed by us on 23/11 and 2022, remanding the matter to the National Green Tribunal. To stop. It will be open to the applicant to file proceedings or applications before the National Green Tribunal or appropriate authority, or take recourse to writ or other proceedings as may be advised.
May I request one more thing? Because the committee has constituted to investigate, there is no progress in it. My lord. Lordship may kindly direct to at least investigate it on its own merit, my lord.
Sorry, please. Next case, please.
My lord, the delay may not come in my way because Lordship may kindly indicate that at least.
Nothing.
I'm obliged.
Yes, please.
My lords have dismissed similar matters, but with my lord's permission, I'll make only one submission and leave it at that, my lord. Only one submission.
Yes.
We are 57 employees of the corporate debtor, my lord. We are getting only 0.97%
Can't be
of
held.
what we
Can't be
are.
held.
This is only because, my lord, of gross undervaluation by the resolution professional. Corporate debtor is given for 826 crores, my lord, just 2 months after that.
We are not going.
Just 1 point, my lord, just 1 point. Just 2 months after the new management takes over, they pass a board resolution to sell assets worth 3,000 crores. They get it for 800 crores and they're selling it for 3,000 crores. This indicates the gross undervaluation.
Sorry, they have to also implement the project. Right now, we do not find in good ground and reason to interfere with the impugned judgment and hence specially petition is dismissed. That's all. Hence the appeal is. Yes, please.
Matter was passed on the basis of the judgment passed in the Jharkhand Urja Vikas Nigam Limited, which your lordship have referred.
No,
in the
please,
Tamil Nadu
let
Government.
me put it. We have already referred that matter to a larger bench. One.
My lord
And
kindly,
the award itself deserves to be set aside.
my lord kindly
No.
attach my matter along with their matter. My lord kindly attach my matter.
Sorry, this is sham, absolutely sham. We are not inclined to interfere with the impugned judgment.
My lord, what the same issue is involved.
Maybe the facts are too glaring. We are not inclined to interfere with the impugned judgment and hence specially petition is dismissed. That is- We don't say anything. How much is the delay?
No, no.
So what was that? You had filed a review.
No, my lord, that delay was wrongly calculated, my lord. Only 85 days delay is there, my lord.
There is substantial delay.
No, my lord, there's only 85 days is delay is there. That was wrongly noted, my lord. I have pointed out with their details.
You are also
Days.
challenging the single judge's order straight away before us because your writ appeal was dismissed on the ground of delay. That's 385 days.
My lord,
Including that,
that
it's
delay was
564 days against the single judge's order.
Your lord.
There is substantial delay.
Single
at different
order was
stages.
passed on the
Just
Jharkhand.
listen. There's substantial delay on the part of the petitioner at different stages in pursuing the litigation, including filing of the present special leave petition. Full stop. Even otherwise, on merits, we are not inclined to exercise our power under Article 136 of the Constitution of India. Full stop. Accordingly, the special leave petition is dismissed. We clarify, question of law is with open. Next case.
My lord, kindly direct to be the MSME. It was remanded to the MSME to be take up the hearing because
Please go there and do that. That will be fair on your part. Go there and do that. You start the conciliation proceedings. Conciliation proceedings do not result in a finding or any settlement. Within 3 days, you pass an award without taking any counterclaim, claim, anything on record. And it is a not complete, not speaking order.
My lord,
And
kindly,
such an order will be even struck down, even in execution. Sorry, next case, please.
my lord, kindly see the.
Sorry, next case.
Award of the award. Kindly see the award. You will come to the page 145.
We have seen that.
My lord,
Next
my
case.
humble request is to come to page 145.
Please, we have dismissed it. That's it. Next case.
My lord, kindly direct to be the MSME to be.
Please move there. Please move there. MSME will.
They are my lord, but they are not
It
taking.
is open to the petitioner to move to the council for disposal, for decision of the arbitration case in accordance with law. What is the arbitration clause?
The arbitration clause is at page number 23. That's the amended clause.
Does the International Chamber of Chamber of Commerce and Industry in Mumbai have an international commercial arbitration tribunal?
Well, it doesn't refer to the, I'll have to find out, but this doesn't refer to the international chamber in
So
Mumbai.
please come to page 51.
Yes, Manoj.
Page 42. Page 42, clause 10, arbitration clause.
That
Should be settled in the International Arbitration Tribunal in the Chamber of Commerce and Industry in Mumbai. What do you mean? It doesn't say so.
This was amended. Can I see the amended?
Which is the amended clause?
That's at page number 23. Starts at 22.
Yes.
Then at 23. Clause 10.1 of the contract should be worded as follows. The parties will take all measures to resolve all disputes, controversies which may arise out of or in connection with this contract by negotiations. All unsettled controversies arising out of or in connection with the present contract should be settled in International Commercial Arbitration Court at the location of the applicant. It's not happily worded, my lords.
The law of which country is applicable?
Then next, below that, my lords, the contract comes into force from the date of signing. The terms of the contract regarding payment guarantees are valid so and so. But now the amended clause does not disclose which law will be applicable.
So what you have not amended says substantive law of India applied.
It says Indian law.
That says Indian law.
That says Indian substantive law of India.
Clause 10.2 has not been amended.
10.2 is not amended.
Learned counsel for the petitioner states that the amended clause 10.2.
That 10.2 is also worded as
Sorry, my lords, 10.2 is amended.
What does it say?
But you've not
It is silent
referred
from
to what the governing.
substantive law.
Where was the agreement signed?
The agreement was signed in Russia. However, my lords, the place of the arbitration would be on the basis which party invokes. I am the first party to invoke. After I invoke, my lords, in fact, there is also an order, my lords. There is also the Bombay High Court in Section 9 has restrained the respondents from instituting any arbitration proceedings or continuing with any proceedings.
How can that be?
Lords,
1 minute. How can Bombay High Court do that?
what happened is,
Then 1 minute, please. It's a anti-suit injunction
yes, my lords,
or anti-arbitration injunction.
anti-arbitration injunction.
How can you then rely upon the arbitration clause?
Well, it's anti-arbitration injunction in the sense. The clause says that the party which invokes that place would have jurisdiction. After I invoke the arbitration, the respondents sought to conduct a parallel arbitration in Russia. We approached the Bombay High Court. It has already been invoked in accordance with the agreement. The jurisdiction
You're going to be in a mess. Nothing is going to happen. We'll issue notice, but nothing is going to happen. You're going to be in a mess. Anti-arbitration injunction with the arbitration clause as it is, it will depend upon law of that Russia because they will be entitled to invoke arbitration as per the clause over there.
My lords, over there also we have moved a motion pursuant to the order of the Bombay High Court not to proceed further.
It's that they amended clause 10.1 and 10.2.
Doesn't say anything.
Been reproduced at pages 23 and 24. He submits that the Bombay High Court has passed the anti-arbitration injunction order against the respondent from proceeding with arbitration at Russia.
Additional documents. 10.
Explain. The issue whether this court would have jurisdiction is an aspect which will be examined, which is an aspect to be examined. Nevertheless, issue notice, returnable. Petitioner also states that the injunction order was sought for as the respondent had initiated arbitration proceedings in Russia. Issue notice returnable in the week commencing 28th of July 2025. Notice will be served by all modes, including Trustee.
Lords, while there is a delay in refiling, I'm requesting if it could be this side of the vacation, so that, my lords, if a tribunal is constituted, we can also request.
No, please. This will require some consideration. This is not going to be so simple as you're thinking.
Because, my lords,
and one of the difficulties would be in a clause of this nature, where the agreement is signed in Russia, whether the Indian courts will have jurisdiction. Please take out the case law.
I will.
Please take out the case law.
I will do that, my lords. I was requesting because 29th May the matter is.
No, please. No, we can't. We will not be able to possibly injunction is still operating.
Certainly.
But that will be decided. Let them decide over there.
Obliged.
And you'll have to also take out the law, because here the difficulty is going to be once the agreement is signed in Russia, then possibly the situs may be Russia. We are not commenting about it. We are commenting about it, but not pronouncing on it. But you'll have to check up the case law.
You consciously remove the governing law being Indian law. You removed that.
It was removed.
But there needs to be some implication to that also.
Well, it was perhaps, my lords, intended based on which party is aggrieved. That's why, my lords. I follow what is falling from your lordship.
That will have to be examined.
Yes.
That will have to be examined.
Obliged.
Please, yes, my lords, we have already circulated a letter in this regard.
There is substantial delay in preferring the present special petition. Even otherwise, we are not inclined to interfere with the reviewing order. Hence, the special petition is discussed on the ground of delay as well. Hence, the application for condemnation of delay, the special petition.
Obliged.
He pleaded chief of army staff and whatnot.
They were the parties in the original petition. I'm not interested actually, sir.
Not this.
Even if the ASG comes and says we'll pay, I'll be happy.
Go for the jugular, things might start functioning.
I don't want to go. I saw that we don't want to involve them at all.
You could have implemented this Sharwan Ram who writes this letter.
That's all. If you have not implemented him, have you? You're not, and you have to implement people by name. You can't implement like that. In contempt, I don't know how they have
allowed it.
Yes.
May I request, Lord, if the
no, you have implemented them by name
and agrees to
pay. And are not implemented the right person.
The people are the same as in the petition.
I know, but then
the names should come.
No, names are there. In fact, names are there. I saw the wrong memo. Probably the memo parties as it was in the original writ petition.
I don't want to trouble anybody, my lord. Somebody
Right on.
can come and tell your lordship and settle the matter.
Issue notice returnable in the week commencing 13th of May 2025. Notice to be served by all modes, including Trustee. First off, we clarify that notice that respondents need not appear in person. Stop. I need not appear in person as stop. Further, the petitioner is directed to plead. That's a PIO. They plead. What's the name of the Lieutenant Governor? Name is Dr. No, this. Okay, why copy? To plead. Shravan Ram, Lieutenant Governor Shravan Ram, who had written the letter dated 5th October 2024 to the present petition. Stop. Notice will be served by all modes, including Trustee.
This one not Trustee.
When was the order passed by us?
20th of March last week.
Last year.
Great.
May I please There's no assurance given. It's a statement made in the court. How contempt lie?
Yes, my lord.
Contempt will not lie.
My lord, just bear me for a few minutes.
How will contempt lie, please? It's not a direction given by or undertaking given.
There was
to
a
the
direction,
court.
my lord.
It's not a direction, sorry, you're wrong.
My lord, I'll read the direction.
Read that direction.
I'll read that direction, my lord. Your lordship may just have a look at, my lord.
I've read it. It's a statement made that they will. It's a statement made which we have accepted, taken it on record, but not fixed any timelines either.
The timeline was not, but it was as early as possible and at the earliest, my lord.
Look, these are political issues. These are also several things which have to be taken into consideration. That's it.
Your lordship may just.
We're not going to.
Your lordship may just have a look at para 50.
We have seen that. We have seen that.
There is one positive direction, my lord, in the conclusion para, my lord. In the conclusion para.
They held the elections, no? They held the elections?
Yes, my lord.
Wait. We are not inclined to entertain the present contempt petition. In fact, we are also doubtful whether the contempt petition would be maintainable. According to the process, the contempt petition is not dismissed as not entertained at this stage.
Your lordship may issue notice to them. Let them come forward. Were they conscientious, my lord, in making this?
Sorry, please. Sorry. Next case.
Else I'll withdraw, my lord. I'll withdraw it.
Learned after some hearing, learned counsel for Petitioner seeks permission to withdraw the present petition in view of the statement made. Petitioner is dismissed as withdrawn.
130 Gs.
9 minutes. Item 9 minutes. It has been dismissed.
Follow the same order.
Same order minutes. I'm grateful.
My lord, this petition seeks. My lord.
And item number 10.
My lord, this petition seeks redress for a serious issue of discrimination, my lord. The denial of testamentary freedom.
There's already a writ petition pending over here, which is
yes, my lord.
Number 135 of 2024.
Yes, my lord.
It's a similar issue.
It is similar, but it is not the same, my lord, because the writ petition which is pending, they are asking the remedy renouncing from the community, renouncing from the Muslim community. But what I am seeking for in my petition,
Petition civil number 135 of 2024.
yes, 135/2024, my lord.
Versus Union of India and others. Notices will be served by all modes, including Trustee.
My lord, may I say one thing? My lord,
My lord.
Your Lordship was pleased to tag with the repetition one. I am the advocate on record in the other matter. There is a slight difference. There the lady has left the faith and she wanted to be governed by Indian Succession Act. Here the petitioner is praying that he still believes in the faith and he wants to be governed by it.
That is fine.
Yes. There is another specially petition pending, Quran Sunnat Society from 2016, 9534. So there, both the believers and non-believers are there. Their claim is that the Sharia in national charge, it discriminates women is unconstitutional. That petition, that specially petition.
We'll see that. Let it come up in that petition. Then when it comes up for hearing, then you can ask for tagging of the special petition. At this stage, just one.
My lord, can it be tagged along with 135/2024, my lord?
Yes, we have done that. We have done that.
Thank you, my lord. Thanks, my lord.
At this stage, Mr. Visham
Prashant
Padmanabhan,
yes, ma'am.
advocate on record,
In 135.
states that there is that specially petition number
9534 of 2016.
9534
of 2016.
of 2016, titled
Quran Sunnat, my lord, it is 9546.
9546 of 2024.
No, sorry, 2016.
2016.
Titled Quran Sunnat Society.
Just write it on a piece of paper.
Yes.
It raises several issues which are similar in nature. Full stop. The aforesaid specially petition will be also tagged and listed along with the writ petition. Along with these writ petitions.
God bless.
Item 11.
Sir, Gauri Shankar, party in person, item 11, joining on video conference.
Yes, please. Mr. Gauri Shankar, go to the High Court. We will not directly entertain it. We have some reservations also on whether you can go into economic policies, because the government of India, when they, or the railways, when they introduce a Tatkal scheme, they also take into account that the fares otherwise are sometimes below the actual costs. So they have to recoup some money somewhere or the other. That we will not go into, because the actual cost per passenger is quite high. The freight rates are in fact subsidizing passenger fares. If you want to go to a high court, you are welcome to, otherwise we will not entertain.
Say something, Mr. Gauri Shankar. I don't know whether he's able to hear.
He must be able to hear, it must be not anxious. Should be fast. So what's probably anxious.
My lords, it's
What a stand.
My lords,
Hats off. Hats off to Bharat Heavy Electricals Limited and the stand taken by her.
my lords, it's the
You appointed the arbitrator.
Sorry.
You go before him and say you have no reservations about his integrity. And once he passes an award, you say no, no, no.
Dismissed with
But
costs.
my lord-
I won't.
but
Should be dismissed with exemplary costs.
My lords, may I just make one submission? Our opinion is now not, my lords, it cannot be. we
So
cannot
your
stick-
opinion changes and we, the other litigant suffers.
Judgments, my lord.
Sorry, please.
Your lordship's judgment.
Sorry, please. You cannot raise that objection. The other side could have raised that objection.
My lords, there.
Sorry.
The Delhi.
In our opinion, the present special petition is entirely misconceived as objection to appointment of the departmental arbitrator
My
should have been
lords.
raised by the respondent. and cannot be raised by Mrs. Bharat Heavy Electricals Limited. So specially petition is.
May I have
Not that your departmental arbitrator is so unbiased and detached. You should in fact promote him.
Malas, the difficulty is, Malas, what happens if we can't challenge the other side challenge?
Not
then
victimize him by challenging his integrity now.
No, Malas, it's not that, Malas, but once your lordships have declared the law that ineligibility is attracted and there is the ineligibility in law applies. On merits, otherwise there is a remand, Malas, the merits will be considered. On merits also the award is.
That's fine, we are not going to that question. It's high time you stop this.
Leave it at that, Malas.
Create a mess, the court sorts out the mess, you keep on repeatedly, despite of TRF and other judgments, repeatedly you raise that please. Now it's sorted out, now you come up, after the arbitration is held, everything has taken place, goes against you. Now somebody in the legal department says, let's take an objection to our arbitration.
My lords, would your lords then consider, my lords, passing a detailed order on this?
No, please, we have passed a single line order. That's good enough. If you pass it, perhaps what is required, even if we have to set aside an award of this nature, probably we'll have to burden you with enough costs because you've made the other person suffer so much.
My lords, what I'm respectfully submitting is if your lordships, I'm not on your lordship's view, your lordships have taken a view, but then kindly say that, would your lordship consider saying that it is not only because we have appointed, because the arbitration has concluded. So that, my lords, then both sides are foreclosed. It can't be that because...
We'll see. Next case, dismissed.
My lords, the repercussions will be on other cases also. So if your lordships if your lordships clarify on appointment and...
We are not going into that question. That's
great.
Just add one. Further, no objection was taken by the petitioner to appointment of the arbitrator.
Even during the hearing?
During the course of the hearing, the hearing in the arbitration proceedings.
Please, my lords. That at least will apply to both sides, my lords. Otherwise, when we will lose, they will come up, my lords. Grateful, my lords.
Please, my lord, this is a fresh section 11, my lord. The petitioner is a 94-year-old US citizen. My lord, both the twin conditions, my lord, of the arbitration clause and section 21 notice having been sent, my lord, both are satisfied. In fact, my lord, the Bombay High Court
issued notice returnable in the week commencing 4th of August 2025, notice to be served by all modes, including justice.
My lord, can I just request for a shorter date? My lord, he's a 94-year-old man.
We are aware, but it will take some time. The response will file their reply within 4 weeks of service. Rejoinder may be filed within 4 weeks after service of the reply.
Grateful.
Your lordship, it's a private border body, and your lordship, the respondent has failed to produce any material evidence on record.
That will be examined. You make a representation. How will the court go into that? You purchase a land which is filled up with water, and now you say,
your lordship, but
please vacate that, take out that water. Sorry.
Lordship,
for us
very small submission, Lordship. If we
it cannot be, we cannot entertain one.
Please, Lordship, because this is the matter of Lordship survival, Lordship. There is a private property and nothing has been changed in that existing.
Sorry, go make a representation.
Lordship, even the locus standi, Lordship.
Trying to interfere with the impugned judgment and especially.
Lordship,
sorry, please.
If locus standi doesn't.
Please, sorry. Go before the authorities.
Lordship, competent authority already is just pressurizing Lordship without proving any documents, without.
Next case. 15 is the NHA. Same NHA. Move before the civil court if you have to, if the authorities do not act, that's it. We don't go into all these questions and everything.
Lordship, then will you withdraw the Lordship, please?
In item number
14, Lordship.
When it comes for the petitioner seeks permission to withdraw the special petition.
Liberty to.
No, we are not giving any liberty. That's already mentioned in that order. Summary of the statement made, special petition is dismissed as withdrawn. 15, same order.
May I find out if this is infructuous today?
What is this? 20% is not mandatory.
But we might have.
And let me put it, 69A is being abused these days by the revenue. Anything which comes, look, there's so many.
Our request is please file a return. This particular has not filed a return for the relevant.
It does, but you have made an addition. Why did you make the addition?
So instead of, my lords, would have it next week. This might have become infructuous, my lord, because we would have passed the assessment.
No, nothing. The only question is deposit of 20% or not. And 20% is for the, in case you deposit 20%, the assessing officer passes an order. And that cannot be a thumb rule. Additions are made. Sometimes justified additions are made. Sometimes there are additions which are not justified. The appellate authority equally has the power to set aside. And there is no statutory provision.
So this is imposed in all cases. This is a special case where they didn't file a return. Not any information.
Please, 20% cannot be made a thumb rule. You're wrong on that. When the assessing, for the administration purpose, you have said the assessing officer has the power not to enforce a demand. You first said 15%. Somebody said, let's collect more taxes. You made it 20%. Fine. But that cannot bind the court or the appellate authority.
My only request, my lord, instead of dismissing this matter.
We are dismissing it. That's it. Specially petition is dismissed. Next case. Delay exclusions. By now, the appeal should have been heard.
Hence my request.
No, but you know the number of appeals pending before the CIT appeals?
That's also hence my request.
5,50,000 appeals are pending before CIT appeals. 5,50,000. You're not inclined to interfere with the impugned judgment and especially petitions. Next case, please.
Great.
Former order, my lord, one appeal is already dismissed. Same order may be passed.
Okay, same order.
Yes, delay of 2 extent. Delay may be condoned.
Yes, please.
110 days delay.
Why before I am allowed to?
610 days delay.
Lord, the report of the handwriting expert has not yet been delivered, submitted in the court of Third Judicial Magistrate, Malda, my lords. Hence, the present proceeding is going on. There is a money suit.
On the application for condemnation of delay, as well as especially petition returnable in the week commencing 11th of August 2025. Notice to be served by all modes, including trustee. So it is submitted. This is a clear case of abuse of process, as the respondent complainant had not succeeded on earlier 2 occasions. He has taken benefit of the terms and conditions of the agreement to sell by, as flats have been allotted to him.
A DD has also been given.
Till the next week of hearing, there will be stay of further proceedings before the trial.
Grateful, my lords. So grateful.
Let's be.
This is that case, my lord.
CFSL report.
Learned solicitor is leading us, my lords. If there's a request, if it can be kept next week, my lords. There's some report.
Report is ready.
And the learned solicitor will make the report.
Please have to tell us whether it's ready or not.
Apparently, it has.
For that, you need the solicitor to come and tell you.
Yes, ma'am.
It's ready.
Yes.
You don't want to share it with us.
My lords, it will be shared, my lords.
Okay. This stated that the report has been received. Rest in the week commencing 5th of May 2025.
Right.
This matter let it go before another bench. We will not be able to, this will require some time. But.
Well, this is only that.
In the compromise.
No, they never even contacted us.
Lord, my learned friend's client filed 4 applications before the executing court. And my lord, I still hear it because even to request your lordships to accept any of the solutions.
We listed before a bench presided over by Honorable Mr. Justice Pardiwala in the week commencing. 5th of May, 2025. Deeply grateful. You have the original documents with you. Good.
No, may I just point out,
That's first.
Yes.
This is the.
Yes, my lord. No, my lord. In fact,
you are in big difficulty.
Yes, your lordships are right to that extent. Now, may I just show one document?
You have messed it up. You have deliberately taken so many.
Can I only make one request if your lordships may consider it appropriate? Only see the seizure memo issued.
That seizure memo is, let's say, the better.
Because they are, in fact, police has filed a counter against me. So your lordships cannot.
No, sorry. They have changed the stand after the court's intervention.
I know. Because from day one, I have been.
Go back. This bail has to be set aside.
Will my lords, at least when your lordships are remanding back, can I only make.
No remanding back. This bail order has to be set aside.
Can I only make one request if your lordships may consider it appropriate?
They cannot pay.
Yes.
It cannot pay. That seizure memo is done at your behest.
No, I'm saying one thing, Milord, only consider. Milord, may give me liberty, only 1 week's time to bring those documents here.
Sorry, nothing.
Yes,
Sorry.
please think.
No, we've given you enough time.
No, I'm saying something else, Milord.
This is a completely a fraud which has been.
Can I make one request?
Once the original documents are with them.
Your lordship, some documents have been shown to your lordship.
That's it. We require the original trust deed and original sale deed.
Yes.
You are a businessman. You're dealing with real estate. You know what is the value of the original document.
Yes. Can I only make one request? Now, let state be directed to bring those seized documents and.
Sorry, we are not going to do that. The state will never get those.
No, because we have handed over with them.
Okay.
If they do not exist, your lordships can pass.
Sorry, please. You would have got the photocopies. Please place those on record.
Photo.
Yes.
Will do. Give me 2 days.
No. You should have done it by now.
May I say this?
No, I'm sorry. You should have done it by now.
Can I only make one request? Because today I go with the presumption your lordships are right. I am saying your lordships.
There's no presumption. We know that.
Your lordships are saying that the document issued by state is a false document, wherein they are saying they have taken original from Lakhvir Singh. Today our presumption is wrong. I am saying let the
that he's a purchaser who had acquired rights in the said land from Mr. Inder Singh and Jasveer Singh, then being a builder, he would have taken into custody the original documents of title.
Yes, not a CLU. My ATS says that I will pay them when my CLU comes. That payment also have an with my affidavit. All payments.
In fact, that's fine. Obviously, you'll do it when you camouflage as per the FIR. The trust, namely
of charitable trust.
What's the name of the trust? Anubhav Charitable is the owner of land bearing number bearing khata number 14/14. Just copy that at page number 88. I've underlined that. And measurings 49 class 9 barlas. Stop. MS Radmon Court is the trustee. Stop. She claims that she has not executed any documents for transfer of for deletion of a name or transfer of or for induction of new trustees, etc.
Resignation, because she denies a signature.
Allowed it as an appeal. You granted anticipatory bail.
Yes.
The application for pre-arrest stroke anticipatory bail in FIR number 510.
Your Lordship may consider. Your Lordship may only have one page of my additional affidavit. What I'm saying is, look, the documents have been submitted for FSL. The police say so. The original is given by me. Only just look at that document. Look, her signatures on resignation have been sent to FSL.
Please, if the original documents are with her, that's it.
Can I even have a look at it if these are the...
Please look at them.
Because not... Your Lordships, can I make one request? Because in case Your Lordship says that police has taken original from me and then handed over to them, it will got...
Sorry, I've not said that.
No, I'm saying...
I've not said that.
In this case, Your Lordship only...
Now you got to that extent, you've cudgeled up a new story. You have not even said that and you can't cudgeled up that story.
If this document is false, then Lord...
Please, it's very unusual. Look, why we are saying that you are hands in gloves and cahoots with them, Lakbir Singh, with real estate. Correct? You're not a novice or a layman looking around for buying a plot of land. It's a trust. The trust was owned by so and so. You also accept. Lakbir Singh, you say, comes and says, I become the trustee. She resigned and she transferred the rights. Correct? Lakbir Singh, you would have asked, how much money did you pay her? One, we don't want to tell you all that. You don't go into all that. You don't take the original documents in your custody. You make payments by check and then you say, I made payments by check at a lesser amount because the property there's some dispute going on in the property, so the market value is much higher. Second circumstance against you. I could have recorded all these.
I'm sorry.
I could have recorded all this. I've deliberately not done. Otherwise, you would have been in a greater problem. You get it? Now what you do is, after the FIR is registered, Lakwinder Singh says, I'm giving these documents to you. You don't give the documents because you want to show that there's a gap between you. It's not it's an arm's length transaction between you and Lakwinder Singh. On the other hand, indications are Lakwinder Singh has been put up by you. Money has gone from your pocket to somebody who's coats, with hands and gloves with you. That's it. It's not, nobody in business will take it for a ride like that. Sorry, next case, please. Certainly, is it a problem?
Can you not at least give me a fresh?
Sorry, please, no fresh application. No fresh application.
This will amount to my clients.
Obviously, he's going to be in a problem. Whether they arrest him or not, we are not given any directions. If they find material, they will arrest him. We have not said anything, but the anticipatory bail cannot be granted. Next case.
This case, I'm not appearing, but he is also someone who has been accused in the same FIR. So, I'll have to be here to see his 22.
Yes.
In fact, based on his order, I was granted anticipatory bail.
My lord, he is the person about whom we got FIR against him. He has done it earlier in 2016 by forging the signature of Mrs. Rajkumar. He has not made any resolutions per se, but he has signed off a forged consent.
My lord, he
has been granted anticipatory.
My lord, I am for respondent number 2, my lord.
Yes.
My lord, the sole allegation against respondent number 2 is that I got the CLU on the forged documents, my lord. Whereas I'll just take my P3, my lord, page 30. Para number 9, 10, my lord. That clarifies the fact, my lord, all those documents which they now say that
21. Yes.
Please, my lord. P3, my lord. Para, for a moment, my lord. Para number 9.
Page number?
30, my lord. 30 of the petition they have filed, my lord. Page 30, my lord. Para number 9 of MOU.
Yes.
My lord, here it is clarified, but that time, my lord, these all documents on basis of which they are saying that I got the CLU in my favor by forging the documents. These all documents have been provided by my lord Sherwood Society, and these documents are all on the basis of these documents. After getting CLU, my lord, rather expenses which I have, my lord, incurred to me, my lord, are of 2 crores, my lord, for getting that CLU.
I understand the later part, what you are arguing.
My lord, to get that CLU also, my lord,
2016, this builder purchased this from this society and trust collectors. 6 acres is with trust, 19 is with Sherwood. So in 2016, this builder entered into an agreement with society, and Sherwood in 2016 applied for CLU, not CLU granted. For 25 acres 8 years ago to society and to Sherwood for 19 acres and 6 acres, the CLU was cancelled. And then in 2022, I stepped in, I paid Sherwood and I paid the society to do this transaction. So the documents which they are alleging, Rajmohan Kaur says that even in 2016, whatever documents were applied to, I did not sign it. So now all these documents have been sent to CFSL of 2016 and 2021 with admitted signatures of Rajmohan Kaur to verify her.
1 minute, please. What is admitted signatures? She is not admitting those signatures.
No. The admitted signatures for purpose of CFSL is that the police tells her that you sign. Give me your specimen signature.
Okay.
We will take it from
specimen
the
signature.
Yes, her specimen signatures have been taken, and all the documents which she are saying is forged.
Again, you did it in 2016, applied in 2016 for getting the clearance.
By the Sherwood Society, my lord.
1 minute. Why will Sherwood Society provide the documents relating to the trust?
Because my lord, if my lord will see, my
Why
lord,
will
the
Sherwood Society provide documents belonging to the trust when the Sherwood Society is not the owner of that land?
No, my lord. They were, my lord, of 12.5 acres of land, my lord.
Correct.
They were.
That's a separate land. That's a separate land, not the trust land. Why will Sherwood Society will that's ordinary. Provide your documents of title relating to a third person. Then nobody gives the document of original documents of title to anybody.
My lord, because if my lord will see, my lord, that as per the as per section 5.1, my lord, 5.2 of
what Punjab is a fact.
Can I answer that?
That is there.
But consider will take license, develop and later pay us. Only consent 1 page letter is required with photocopies of the documents. Originals are never to be submitted to the authorities for taking societies together, applied by
His FIR. No, Milos, it is about faith and Milos.
This is
he admits, Milos, that he comes to my house to besmirch, besmirch my girl, Milos. So Milos must see the FIR. FIR, he said that my son had gone to a rustic village to meet at 11 in the night.
You see injuries, Mr. Divyesh. And that 14, and the hit is by rods in the court says it will be 304.
Learned, the Honorable High Court has given him liberty to file an application of Section 216. And Milos,
sorry, the High Court should have interfered there and then.
No, Milos,
should have been sensitive to the cause.
Understand, Milos, what is
interfered there and then. No, Milos, should have been sensitive to the cause.
Understand, Milos, what is going on in the Lordship's mind, Milos. What has happened is, Milos, what has happened is that Milos, now PW1 has been examined.
No,
he can very well,
Chief is going on. Only Chief is going on.
Go and file an application of Section 216, Milos.
That's
if there is anything,
right on. Leave granted.
My lords may also hear.
May I say, Milos, one thing, Milos, before your Lordship, Milos.
We are appointing a special prosecutor in this case. Please suggest a name if you have to.
I can take instructions.
Have to.
I can take instructions, my lords. My lords may. If my lords will permit, my lords have expressed a view, which is clear. But if my lords will, without prejudice, allow me only to make 2 submissions. But in any case, my lords may give me 2 days for appointment of special prosecutor, my lords.
No,
for names.
We'll dispose of this special petition and we ask you to appoint a special prosecutor to deal with the matter. This is a case listed so lightly.
My lords, there are two respectful submissions if my lords will permit us to make without prejudice, my lords. If my lords will permit us to make without prejudice, my lords. My lords have categorically expressed a view. However, the 26-year-old man, 18-year-old daughter, of the house at Midland.
But there are, look, look, you cannot like anybody.
No.
Should they have? Please, leave granted.
Milos, there's one more submission.
Please, leave granted.
Milos, there's one more submission, Milos. If your Lordship, Milos, because we were in custody for some time. Your Lordship, Milos, if your Lordship would direct Milos that 302 also be invoked, then Milos may say that the bail which has been granted to under Section 304, we stand good also, Milos, and we were directed to execute our bonds.
Right.
Please, Milos.
Leave granted.
Then we were directed to execute our bonds.
Right.
Please, Milos.
Leave granted. We have examined the post-mortem report. Records that the deceased was due to shock and on the question of place of occurrence as well as on the question of place of occurrence, there is no doubt or debate. Full stop. Next one. Learned counsel appearing for the appellant. HON'BLE, the father of the deceased, submits this is a case of honor killing, wherein the family of the girl had beaten the deceased with sticks and rods with a clear intention to kill and murder. Stop. He submits. This is from the nature of injuries mentioned in the post-mortem report. Next paragraph. We are a little surprised why the charge sheet was filed and invoking Section 304 of the Code of Criminal Procedure, Indian Penal Code, sorry, and thereafter, at the time of framing of charge, the trial court framed the charge under Section 304 of the Code, simply recording page number?
The trial court judgment is page 83, my lord, and the relevant finding is page 85. The trial court says that since there are no firearm injuries, therefore 302 is not. Page 85, my lord, bottom. As per post-mortem report, there are 14 injuries. In fact, I filed my application before framing of charge only, my lord. Page 74 is my application. Before framing of charge.
There is no prime facie basis for framing of charge under section. HON'BLE, in fact, had filed an application that the charge should be framed.
Page 70.
Under section
70.
You had filed an application that the charge should have been framed under section 302, as the post-mortem report had also found that the deceased had suffered pleural hematoma on the head and left side of the brain, and parietal and frontal bone were fractured. Just copy this also. Your post-mortem report is in fact incorrect.
The typing, they added the of antemortem injuries. Yes,
you mentioned that.
He died as a result of antemortem injuries.
The death was as a result
page 20.
Of antemortem injuries. Page 74 is there. So stop. On the contours of the aspects which the court must take into consideration while framing of charge, this court in Ghulam Hassan Beg versus Muhammad Makbul Magre, 2022, 12 SCC 657, has referred to, has observed that the court, while framing charge, undoubtedly has the power to sift and weigh the evidence, but the same is for the limited purpose of finding out whether or not a prime facie case is made out. To stop. When the material placed before the court disclosed grave suspicion, which is not properly explained to the court, the court would be justified in framing charge and proceeding with the trial. Specifically dealing with the question whether a charge should be framed under section 304 or 2. It is observed as under copy paragraph 33. So stop. In this case, we find on the facts just above, the charge should have been framed under section 302 of the Penal Code and not under section 304, as has been framed by the trial court and upheld by the High Court. Stop. The impugned judgment is accordingly, the High Court and the trial court are accordingly set aside. The charge will be treated as, the fresh charge will be framed under section 302 of the Indian Penal, read with section 34 of the Indian Penal, of the Penal Code, and the trial will proceed accordingly. To stop. The appeal is allowed in the aforesaid terms. We have clarified that the observations made in the present order will not be read as observations and findings on the merits of the case. But the trial will proceed in accordance with law, and on the basis of evidence and material, on the basis of evidence led during the course of, and the final decision will be on the basis of evidence and material laid before the trial court. Next paragraph. Keeping with the nature of allegations and the manner in which the trial has proceeded, we would require the state of Uttar Pradesh to appoint a special prosecutor after having a word, after speaking to HON'BLE, the father of the deceased, to conduct the said trial. Most of the said exercise will be completed within a period of 6 weeks from the date copy of this order is served on the director there's a prosecutor's office in the state of Uttar Pradesh.
My lords, I'm not exactly sure, but we will, if my lord says 6 weeks, we will comply with that, my lords.
From the date copy of this order is served on the Chief Secretary, State of Uttar Pradesh. Stop. The compliance report will be filed in this court.
Milord, may I say that Milord, the bail granted to
Milord, I have objection.
We also have clarified this order will not affect the bail which has been granted. But it will be open to the respondent. Number
225.
225.
Private respondents plus 226.
226. The private, it will be open to the private response 226 to move an application for bail before the trial court.
Much obliged.
In view of the amended charge. So stop. The said application for bail will be considered within a period of 3 weeks from the date of filing. Till the application is decided, the respondents 225 will not be taken into custody. 225, not 6.
225, yes, sorry.
225. Need not be taken into custody.
Lord, may I submit the trial court may independently decide that bail application?
That bail application will be decided on its own merits.
Much obliged.
Extremely grateful, my lords.
Please, ma'am. Plus, the entire FIR has been quashed by the Honorable High Court, on allegation that the officers are not implicated, the names are not there in the FIR. Lordship, may kindly see page number 5, ma'am. It's coming after notice, ma'am.
Yes, please.
Paragraph number 6, ma'am.
Yes, what do you say?
Please, Minister.
How can this petition be allowed?
But your lordships may kindly say that
It's allegations.
two aspects, my lord.
Severe allegations. How can it be? You question the FIR itself.
But no, what the
FIR need not disclose the name of the criminals or the accused. It's an offense which has been committed.
I'll just point out what is my. This is one of the points. I had raised about 6 points before the High Court. High Court has considered this, my lord.
So what can be done?
No, there are 5 more points also.
What are the 5 more points?
I'll just point out.
This point is really, look, there is forgery, there is wrong allotment of land. You accept that?
No, my lord, dear lordships may kindly say allotment is made in 1999.
No.
Pardon?
Allotment is made in 1999. I was there from.
That's what quashed the FIR.
No, but your lordships may kindly see here.
FIR.
No, but your lordships may kindly see here. There are 3 aspects. Your lordships may kindly. There are 3 aspects. Your lordships may kindly consider. Firstly, so far as in this case is concerned, my lord, High Court has given a reason stating that it is actually a malicious prosecution, my lord.
What is the prosecution? Can you say so in 482 when FIR is simply registered and they are making allegations that land has been transferred?
FIR is registered only against me, whereas there is no allegation against me.
1 minute, please. FIR is normally registered for a crime. Even if the name is mentioned, that is immaterial because if you're not involved, the prosecution will not, the crime will be, they will not be prosecuted. But as far as the offense is concerned, it is certainly made up. Court could have said, mere mentioning of the name of so and so should not be read as if he is the accused. The allegations are there with regard to forgery and transfer of land. That can be examined.
Against unknown persons, let them do it, my lord. No. But why I should be named, my lord? That is my respect.
Relevant period 2015 to 20.
Pardon?
The relevant period is 2015 to 20.
Not 1999.
No,
No,
Page 67.
Page?
67.
Right.
Specific allegation.
Page?
Page 67, the paper book. And deeds under the government shelter scheme created fake accounts, which is e-Khatha. Documents not for the non-beneficiary persons and did not make any of the accounts of the panchayat. They have an account on this cyber, which is e-Khatha. There is no records related to those documents available in the Gram Panchayat. Also, in the next page, also destruction of the document with the help of the
case against you.
No, your lordship.
Specific case.
Kindly look at my counter because they have not produced.
Okay, let's see your counter.
Kindly look at my counter, my lord. First, your lordship will find annexure R have produced, which is Ashraya scheme, my lord. Your lordship will find it at page 13 of my counter, my lord.
Another FIR registered against officers, same allegation, same 21 clothes.
And there was one issue,
I have produced that also.
it was filed in the anti-group bureau department.
It's not a case for quashing.
My lord, your lordship may kindly see, your lordship may kindly consider, my lord, kindly come to page 13 of my counter, my lord.
We are passing a short order, not a long order.
But then in that
If you produce the allegations in the FIR, you'll be in a difficulty. You're simply going to say the court should not have gone to the cross allegations.
But in that case, your lordship may remand the matter because
No,
I have, my lord, I have kindly then consider my points, my lord, before your lordship.
Not required to be considered in FIR.
I fall
You're not required to be heard.
I fall within the categories, my lord, which are set out in the.
Doesn't make a difference, right?
Just-
Our attention is drawn to the allegation number.
Page 67.
1-5, even that 2021, page 65, registered at so-and-so police station, under sections 420, 468, 465, and explain. We have also examined the reasoning given by the High Court in the impugned judgment, quashing the said FIR. Stop. In our opinion, the High Court judgment is unsustainable and should be set aside. Stop. At this stage, FIR, the assertions made therein have to be taken into consideration. Stop. The respondent number one. By a short order, scuttle the entire investigation itself. After observing, no doubt, the reading of the entire complaint indicates that, FIR discloses commission of an offence. Once it's satisfied, the High Court should not have quashed the FIR itself. Impugned judgment is accordingly satisfied. The appeal is allowed in the aforesaid terms. We clarify, the order would not be read on the merits of the case or the allegations made to verify.
Liberty. In that case, my lord, your lordship may kindly give me liberty, my lord, that in case.
All fees and conditions available to the parties, that is the appellant as well as the first respondent, SC Suresh, are left open.
No course to receive.
Next case.
Well, no persistent will be.
No. We are not.
But your lordship may kindly.
We are not giving any.
Your lordship may kindly consider.
Our left open fees and conditions are.
Very same page which your lordships have read, my lord, your lordships will find there are four. What they have stated is it is the piece.
We have said all fees and conditions are left open. That's it. Next case, please.
Petition of 2014.
Learned ASG's opinion.
This has become infructuous, my lords. So for the purpose of consideration.
Are you enjoying this then? Or you are the ones who, the matter is going on before the Delhi High Court? Well, this should
The
be.
order dated 8/1/2000.
So, but why do you want, let the Delhi High Court decide the matter?
We wanted to remand it back because since it has been delayed on 25th of.
So you withdraw this transfer petition?
We want, yes.
Current counsel for the petitioner seeks permission to withdraw the transfer petition.
With the
In view of the statement made, transfer petition is dismissed as well.
Grateful, my lord.
The two matters of similar nature.
There is no doubt there, but did not approach the designated officer. Instead, moved the application before the High Court.
What difference does it make?
But he should have approached the designated officer for arbitration.
No.
Paragraph.
And it went on with their own consent earlier.
Office report service is also incomplete. Lordship may allow me to file my wakalatnama and response.
Service, I believe, is complete. It's just that they haven't entered appearance.
In relation to respondent number 1, it is
In which matter?
in first matter.
29, I'm seeking for the password. The first matter. 25, I was seeking a password.
May I request your lordship to take it up next week, your lordship.
In the judgment, it says, judgment by the constitutional bench judgment. It should be specifically addressed.
No, my lords.
No, it has.
No, my lords. In fact, we
Because,
are also relying on the same constitution bench judgment.
You should, but then accept the consequence also.
Lordship, then
Consequence, we can't erase the arbitration clause.
And I don't think that was the
And
intention.
there is, if I'm not mistaken, an item number, just give us that earlier, item
25.
25 is a reference to an earlier judgment of this court wherein such an arbitration, the arbitration clause was upheld.
please, my lords, Kashish developers, your lordship.
No. Kashish is on a completely
No,
different point.
arbitration judgment, the clause
Kashish is
was
a
upheld.
judgment where the SLP is dismissed.
In Indian Oil Corporation Limited and others versus Raja Transport.
That's Justice Ravindran's judgment in Raja Transport. But that's right. But Milords, and that's
That was against this view.
correct. But that's a slightly, and I'll Milords be able to explain that judgment away. That's not a problem at all. Milords. That is not going to come in the way because
Of these matters you said, the list. This Badiwala in the week commencing 19th of May 2025.
Milords, that's likely to be the miscellaneous week. That's the only consideration. Milords.
13th of May 2020.
Lordship pleases. Lordship pleases.
I thought it will be probably shifted because just the first day is normally not taken up. They would have given a date of choice before I made it to the last week. If I'd given it in July, it would have pushed around more. It won't be taken up on 9th, in the week commencing 19th. Some date would be given by the Honorable Judge.
I know, but the only thing.
Okay, we make it 30.
Lordships may have done that.
I'm so deeply grateful.
Well, I'm appearing for the Union Territory. I'm seeking some time to file the compliance minutes.
the week commencing 11th of August 2025.
I'm so grateful. Deeply obliged.
11th of August 2025.
What I'm submitting is, should the compliance come even by now? Maybe we may not insist a lot on this. But
What compliance they want?
Lord,
They want to be regularized. So is that a contentious issue?
No. Well, judgment is attained finality in the sound of litigation by the Honorable Red Court based on 2016, upheld by the Honorable Division Bench and SLB.
We'll see.
Dismissed by my lord.
Next case.
I'm so grateful. Deeply obliged.
Please, Lord.
The High Court. Well, the High Court had protected me for 2 years. I have cooperated. The reason for giving me protection.
You have taken 39 lakhs.
Well, that's what I'll try to explain. If your lordship sees what happens is this. I was working in this pet shop.
Daily protection doesn't mean anything.
No.
Because these people were under surgery and you took full advantage of it. It underwent full.
Nothing of that sort happened, my lord. I have maintained a diary. I have kept, please consider.
Money came to your account.
You paid 65 lakhs.
I have paid 65 lakhs.
The balance
Paid
also
39.
No, even, it was not now. It was that time, that period. I have been paying regularly.
Sorry, please.
Just consider this. I have got a diary.
Please.
I have got a diary. I have maintained
Sorry.
everything. Consider this.
Sorry, they become bankrupt. They
No,
took
they
the loan.
That's not right. What they are saying is not right.
Sorry.
Apparently, I have, if your lordship sees the additional document which I have filed, I have kept the entire diary. I have paid.
How did the money come to, so much money come to your account?
No, that's what I'm saying. There is a loan borrowed from the bank that they have said that
Sorry. We are not inclined to interfere with the impugned judgment and especially petitions.
Whereas.
In 32, well, it's because of the Good Friday and the holidays. On Wednesday, brother, I'll have this. Wednesday, only this. I just don't want
We have shown it only for
we tried, person has flown, but it actually flown. Wednesday is about 2 days after the holidays open. Lordship allows that. I'm only asking for.
Lordships have kept it. I mean, it's only to find out if they are putting.
Well, that I will put your Lordships on Wednesday. Either way, your Lordship will either have it or not have it.
In order to enable the appellant to inform the court whether these 300 crores would be paid or not before.
So Lordship will not say honorable. Let me come back with the offer on Wednesday. Then
Will be paid.
No. I will tell you
Will
on the
be-
offer balance on that day.
Can be paid, relist in the week commencing 28th of April 2025.
But if my it can be even before.
On that day, so could it be on?
Let him come.
Very well.
But could it be on the 28th?
I normally give it in the week commencing.
All right, very well.
My lords, this is a very unfortunate case wherein, my lords, my application for recalling was dismissed, my lords.
What you had me done, twice it's been dismissed.
Yes, my
And
lord.
you are working, you are also working.
My lords, but it's about 130 kilometers, impossible for
No,
us to
sorry,
travel.
please. You are capable of doing it.
My lords, we have checked.
No, please.
Until the matter was filed, recalling
Doesn't-
application was filed, my lord.
No, you can't repeatedly do this. We are not inclined to interfere with the impugned judgment and especially petitioners. Yes, please.
My lord, I beg to appear for the petitioner.
Yes.
My lord, the petitioner Jamaat has. May I, my lord?
Yes.
My lord, the petitioner Jamaat for the last 58 years has been administering the Waqf property at the instance of the Waqf board. My lord, after 58 years, a person claiming to be a legal heir of the Waqif files an application to be appointed as a mutawalli of the Waqf. My lord, this is against the canons of Mohammedan law. My lord, I take my lordship. And it is in the teeth of the decision of this court, my lord.
Not sending the right signal.
Removal was on account of wrongdoings. The earlier removal was on account of wrongdoings.
Yes, my lord.
So now those wrongdoings are not there as far as the new one is concerned. But before that, it was normally hereditary.
My lord, in fact, my lord, I would rely upon the dictum of this court.
That's true.
Court of head. My lord, there is no right. My lord, there is no right. My lord, I take my lordship to page 18, the internal page 18 and paragraph 43. There is no hereditary right to be appointed as a mutabali. The only exception is, my lord, I have to plead custom.
That's what.
There is custom here.
But I thought here, what has been pointed out is that in this case, normally it was hereditary. There was some misdoing by one person. There was misdoing by one person.
Yes, my lord.
And therefore, the board had to step in.
Yes, my lord.
So now that the person has died and the other person has now come forward, the High Court felt it should go back to the original.
My lord, my lord, here it is not the case that the petitioner died. My lord,
earlier Mutwalli has died.
No, my lord. The Waqif died. Subsequently, her daughter
Yes.
the Mutawalli.
And she has died. She's also died.
No, she was removed.
She was removed. After removal, she has died now.
My lord, that is not the position here.
So she's not the one who's wanting to become the Mutwalli.
No, my lord, no.
Somebody
that is
else.
another person.
Yes.
Before 58 years.
Okay, show us what is the law.
My lord, at paragraph 43, my lord. Internal page 18. Thus, we may conclude that while no person can claim the office of Mutabali by virtue of being a heir of the Waqif or the original Mutabali, if they can show through a long established usage or custom of the founder intended the office.
But in this case, when was the Waqf form?
My lord, 1949, my lord. Waqif Nama is 1948.
48. And till when was from the family?
My lord?
The Mutwalli is appointed from the family itself.
My lord, 1966.
48 onwards, the Mutwallis have been from the family.
Only one Mutawalli, my lord.
One Mutwalli.
That is the daughter.
And when was she removed?
My lord, in 21/11/1966. She was removed because they wanted to alienate the property.
Right now. Returnable in a week commencing. The 18th of August 2025. Notice to be served by all votes, including trustee. The trust for the petitioner has relied upon the judgment of this court in 2019, 16 SCC 1 to submit that the impugned judgment is unsustainable.
I may pray for a stay also, my lord.
No,
my lord. The only difficulty is, my lord.
We'll see.
My lord, he should not take over the.
No, we'll see.
He shouldn't be appointed as a Mutawalli.
Next case, please.
My lord, only for the interim basis.
They're both in the special petition and the application stage. Next case.
May I please, Your Lordships. Lord, there's a fresh application on behalf of the Board of Secondary Education only on the limited issue of untainted people. My Lord, since 2000.
When are you holding the exam?
Yes, my Lords. The state government has already written to the state commission to initiate, my Lords.
I am appearing for the state, Lord.
State fellows, we have initiated.
I am for the board, my Lords.
1 minute, please. Mr. Devedi, when are you holding the exam?
Lord, we will complete the whole examination within
I'm sorry,
3 to 4 months.
the
Lord.
SSC has to hold the exam.
Not
We
beyond
have
4
started
months.
the process. It takes a little time, my lord.
When will you
Because,
start?
my lord, first of all,
When
the
will you
rules are
issue the advertisement?
My lord,
We'll start the process
just
in 1
explaining,
week's
my
time,
lord.
Lords.
We start by the rules
By
framed
December,
by the
my lords, it
government.
should be done. We'll do it by December, my lords. Preparing for the state, we shall finish it by December. We shall complete everything by December.
My Lords, our difficulty is in
When will you hold
2016, there's no
We have,
When will you take out the advertisement?
Yes.
Give us the date. Outer date.
by May, my lord, we'll take it out because, my lord,
I
rules are,
means
rules are
That
formulated
means
before that.
that advertisement will be published in April.
May. Because, my lord, first step is the state formulates rules.
Rules are already formulated.
No, my lords, we have to fresh rules.
Fresh rules
end
have
of
to be
April, they'll be formulated by end of April.
Rules are
The next step is the advertisement, and my lord, there will be 4 advertisements, 4 different categories.
Okay.
And then, my lord, the exams, and then
We will only grant extension to the teachers.
Yes.
Not to the class 4, class C and D. Sorry.
Not.
Because there is vast case bungling in that, which is quite apparent. CND will
But
not be there.
schools
One will-
require the
maybe
non-teaching staff as well.
non-teaching staff, their schools will have to deal with it. Sorry.
My lord, it's your lordship's prerogative. The only thing your
There are
lordship must keep in
6,000
mind is,
there are
since
6,000.
2016, there has been no recruitment because of this litigation pending. So we are actually understaffed today in any case.
We are concerned about the students and therefore we permit them to join in. But then you have to give an undertaking that the advertisement.
By December, everything will be over.
But the advertisement will be out by 31st of May, 2020.
We'll do that, Lord. We'll do that.
And in case it is not out.
No, my lord, advertisement should be out by 31st.
We shall do it, Manoj. It's our
It will be done. It will be done.
We'll do that, Manoj. We'll do that.
And the process will be completed by
December, Manoj, every December.
31st of December.
Correct. That's all we want.
Lord, your lordship, Lord, when the petitions are be heard, Lord, try, Lord, to segregate, Lord. Para 28 says, Lord, that the segregation is impossible. Today, Lord, only 2 submissions. Today, Lord, we don't know, Lord, who are tainted and who are not tainted.
Lord,
So, one second.
My learned friends have been, Lord,
For the
making an incorrect statement.
Let him argue.
My heart,
If we agree with him, we'll put it to you.
our heart bleeds for the children, my Lord, but it is their responsibility. Today, all of them are, we are here, my Lord.
What do we do?
We are, all of us are here, my Lord.
What do we do?
No, no, correct.
Milord,
The suggestion is, my Lord,
I have one.
so this is a classic way, my Lord, to circumvent, my Lord, the order of this honorable court.
It is only for a
B
period
parties,
of
my Lord.
4 months.
Milord, why don't the retired teachers be appointed for this time period?
My Lord, we
Milord,
are
I
here
put a
because of
question,
the
my Lord,
board, my Lord.
myself, why the retired teacher? Because there are provisions in law. There
And
are
my Lord,
provisions in law.
I would suggest,
And my Lord, even my Lord, High Court, Supreme Court, retired judges,
my Lord, there are, my Lord, retired teachers, my
administrative
Lord.
exigency, my
We are
Lord.
not going to.
They are not under any cloud of doubt. These people are cloud, my Lord.
MA number 709 of 2025.
That's right.
We are inclined to accept
And not yet, least not
prayer
yet passed.
made in the present application insofar as it relates to the assistant teachers for classes 9 and 10, 11, classes 11 and 12.
9 to 12.
9 to 12.
Oh, these are two separate
Very
classes.
well. 9
9,
and 10.
10 is one category,
11 and 12 is another category.
Yes. Separate rules
Subject
also.
to the following conditions. 1. Advertisement for fresh recruitment shall be published on or before 31st of May 2025. 2. Examinations and the entire recruitment process will be completed by 31st of December 2025. Full stop. The state government, the board, and
Commission.
the commission
Secondary.
shall file an affidavit on or before 31st of May 2025, enclosing therewith a copy of the advertisement as well as the schedule, so as to ensure the completion of the recruitment process by 31st of December 2025. Full stop. In case advertisement is not published by 31st of May 2025 and the affidavit is not filed by 31st of May 2025, the appropriate orders will be passed by this court, including imposing costs and publication of the present order.
Only one.
Next paragraph. We are not inclined to accept the prayer in the present application so far as where I've said untainted. We are not inclined to accept the prayer in the present application as far as Group C and Group D. Group C and Group D employees are concerned, as we feel the said as the number of tainted category candidates in the said established tainted category candidates in the said classes are substantively high in number. First off. Secondly, what has prompted us to pass an order in respect of untainted assistant teachers is that the students should not suffer. Students undergoing studies should not suffer on account of the order passed.
In fact, so far as
which has resulted in the order passed by the
Milord, the language used in your lordship's judgment is appointees not found to be tainted.
Not specifically found to be tainted.
Not specific, not yet found to be tainted.
Not specifically paragraph 46.
I'm deeply
Milord, one more thing, Milord, the tainted candidate, Milord, should not go to school. Milord, that may be recorded.
Find this expression.
Milord, the tainted candidate should not go to the school. Milord, that may be recorded.
May I pray two things, my lord? Just one. Till date, my lord,
Milord, kindly be recorded that the tainted candidate.
my lord,
But I humbly submit, Milord, that tainted candidate should not go to identify tainted candidates.
Case, you know your result.
my lord,
No, I'm only saying.
Milord, may I just
I'll add one.
Milord, the identified tainted candidates, my lord, should not go to the school. Identified tainted candidates, my lord, that will create, my lord, something difficult for the children.
Milord, only one thing.
They are the economically the poorest.
No right accrues will not in favor of anybody. No right accrues. Otherwise,
Will not be read as conferring any special rights
on those who are ad hoc
or advantage on the aforesaid teachers. It's so far as the fresh recruitment process is concerned. Next case.
Great. One thing, my lord, the OMR sheet not yet uploaded because the High Court order, my lord, there is a specific direction, my lord, for publishing the OMR sheet, my lord, for public being. Otherwise, my lord, it is not be identified who are tainted and who are untainted.
This is going
My lord, that ought to
it
be
is
published,
already
my lord. Otherwise, my lord,
identified.
the whole thing will be.
The identified tainted candidates, my lord, may not enter the school.
Tainted will be a very broad stroke and there'll be many who will be put under the bus because of this.
Milord, the list has already
Who are not.
Milord, it has been prepared. Let me assure your lordship, Milord, the list of persons have been prepared.
Once the matter is over, please do not argue.
But at least not
We
yet
give the
published.
appearance, lordship, because our names have not got reflected in the portal.
Going to the school.
Next.
Who are going to the school, they.
But may give the appearance in 35, our names have not got.
Okay, fine.
I'll just, I beg to appear for the appellate.
Yes, please. Look, it's like this. 1 minute, please. It's like this. As far as the Electricity Act is concerned, there's screwing up done from time to, there's